We will not bow down to racism.
We will not bow down to
injustice.
The landmark case, the New York Times versus Sullivan, was decided on March 9, 1964, when the U.S. Supreme Court will rule in favor of the New York Times. This case would reverse the decision originally decided by the Alabama Supreme Court. In the United States, during the 1950s and 60s, the civil rights movement was in full swing, as African American men and women could no longer tolerate the racist laws, the abuse, and the overall unjust and unfair treatment they had been receiving. Reverend Dr. Martin Luther King Jr., the moral leader of the civil rights movement, had been arrested during a peaceful protest in Montgomery, Alabama by the Montgomery, Alabama police force. This arrest would mark the Reverend's fourth arrest in Alabama. Civil rights leaders would publish an ad in the New York Times entitled "Heed Their Rising Voices" to raise support and funds for Reverend Dr. Martin Luther King Jr.'s defense. In the 1964 case, the New York Times versus Sullivan, the defendant, the New York Times, was being sued for defamation by the plaintiff, Lester Bruce Sullivan, the Montgomery, Alabama Commissioner of Public Affairs. Sullivan claimed the article "Heed Their Rising Voices" had damaged his reputation. The ad, "Heed Their Rising Voices," never mentions Sullivan by name, but Sullivan states the remarks made about the Montgomery, Alabama Police Department in the New York Times were false, and the negative press about the police department in which Sullivan governed was a negative reflection on him. Defamation is a false statement about someone to a third party designed to hurt, damage, or destroy the reputation of someone else. Libel is the print or published false statement about someone designed to damage their reputation. In the New York Times article, there were a few minor errors. For example, the article stated that King had been arrested 9 times. In fact, he was only arrested 4. There were just minor errors, not trying to damage the reputation of the police department. In this case, because Sullivan is a public figure, he has to prove the New York Times published this article with malice. In this case, the U.S. Supreme Court sided with the defendant, the New York Times. Under the First and 14th Amendment, a state cannot award damages to a public official for defamation. Sullivan had the burden to prove that the New York Times published the article with malice. Gertz versus Robert Weich, Inc. was a landmark case where the U.S. Supreme Court will use the First Amendment to make a decision on a defamation claim by a private person. In the U.S. Supreme Court case, the petitioner, Elmer Gertz, a private person, is suing the respondent, Robert Weich of Robert Weich, Inc., for publishing an article in the American Opinion defaming Gertz's character. Robert Weich published in the American Opinion information about Elmer Gertz that was based off pure hearsay. He said that Gertz was a criminal and had a criminal background. He said that Gertz was a communist fronter. He also stated that Gertz was a Leninist. He also stated that Gertz was an architect of the frame-up. Welch didn't verify any of the information about Gertz before publishing it. He published the article based off personal feelings about Gertz and information that was based off clear hearsay. Everything that Welch said about Gertz made Gertz look like a communist crook. Gertz stated that the article damaged his reputation as a lawyer, and it also damaged his personal image overall. To avoid lawsuits like this one, I would have done 3 basic things. 1. I would have given the article my unbiased opinion before publishing. 2. I would have fact-checked the information to make sure the information is truthful. 3. I would cite my information. In the New York Times versus Sullivan, the U.S. Supreme Court ruled that Sullivan, as a public figure, could not prove the New York Times published an article with malice against Sullivan. In the case of Gertz versus Robert Welch, Inc., the U.S. Supreme Court ruled in favor of Gertz, a private figure. Welch could not use the case of New York Times versus Sullivan because Gertz was a proven private person. In the beautiful state of North Carolina, the state uses the basic laws of defamation. Libel in North Carolina, a person has to charge another with the following acts: to say a person has committed an infamous crime, to say a person has an infectious disease, to falsely accuse a person to get them impeached or to lose their trade or profession, to otherwise ridicule or disgrace them. What I've learned from these cases. In the case of Gertz versus Welch, I've learned that you cannot produce a product based off personal feelings. As a public relations student, I have to be unbiased in producing information for the public. In the New York Times versus Sullivan, I've learned a public figure does not share the same liberties as a private figure when it comes to defamation. I would like to thank everybody for viewing this presentation, and I would like to thank my professors at Full Sail University. Thank you, and you have a great day.